morning, everybody.
Thank you, Chairperson Commissioner Musi. Chair, we are almost ready to proceed, but before we can proceed, Advocate Seniors wants to address the Commission in respect of an application we intend to do.
Thank you, Mr. Chair. I confirm audit
position is that we have knowledge of the fact, and you may have seen in newspapers in the recent past couple of years, when these issues relating to our client's position and or the arms procurement process, although there was wide publication of certain allegations and or issues that he had been involved with, according to certain of the press statements and according to the books, you would have never seen any photographic material of our client. He's a very private person, and until this stage there's no photographic material of him available in the press, which gives him some freedom of movement and is a very important factor to his safety. If it is allowed today that widespread photographic material of himself being made available, then you can see what type of hype these proceedings have been created today, and that will mean that probably everybody in South Africa will immediately recognize him if he's in the public as from today. And that then will, of course, include his family. Unfortunately, there was previously threats made, etc. I don't want to go into any of the detail in this regard. And our client, and we submit that it's just not necessary for purposes of this proceedings that we jeopardize that position of our client, especially under circumstances where it would not curtail the functioning of this commission. The request that he make, we feel very strong, and I make strong submissions in this regard, that it will not create the functioning of this commission in any manner whatsoever. It will not curtail the rights of the public to come and attend, the right of the press to attend the proceedings and to publish whatever they deem necessary with reference to the evidential material that he provide. The fact that a photograph being taken and or published with great respect does not assist the commission in any manner. It would not in any manner contribute to the content of any publication and or media report in this regard. It will just create, with great respect, maybe sensation on the one hand, and that must be seen against, as what I've already explained. I don't want to repeat it. It won't strengthen it. The possible jeopardizing of his safety, his privacy, and also that of his family. As you please.
Advocate Sele, just help me. I seem to be having difficulties in conceptualizing what you're asking us to do. My first difficulty is, what authority do we have outside this chamber? Can one give an order which is binding to people who are outside this chamber? That's my first difficulty. The second difficulty is, can we give an order saying that the newspapers or the electronic media should not publish a photo of Mr. Hlongwane wherever they want to publish it? Do we have powers to do that?
No, Mr. Chair, I think you're right. You don't have the authority. You don't sit, although you are both judges, you don't sit as a court of law. So I can't make a submission that you can prohibit the publication of any photographic material outside this premises that falls within your jurisdiction. But what you can order, and that's all we request, is that the taking of photographs and or the making of video material and or the focusing of cameras on our client during the proceedings in this chamber should be prohibited.
In other words, you're asking us to make a similar order that we made in regard to or with respect to General Steyn.
More or less the same. I don't think that I read it. I don't think it went as far as to exclude photos taken by ordinary cameras, although usually they don't do it. But that is, you're right, that is a more or less similar request and or a similar arrangement that we request.
And then the last thing, would I be right to say that our powers and authority extends only insofar as we are here in this chamber during the hearings? What happens after the hearings, we cannot control.
In order to give it practical effect, I would submit, Mr. Chair, that you can make the order relating to this chamber, the premises that's under your control. So what I would submit that you can say is that the prohibition will be in force even if you adjourn for a tea time or a lunch time, but only whilst our client is on this premises. If he leaves the premises, clearly you don't have the right to prohibit the press to take a photograph in a restaurant next to this premises. So just in order to give it practical effect, we would submit that you can make the order a valid order for purposes of the proceedings in this auditorium as well maybe as the foyer, up and until our client leaves this premises and or the foyer. From there on, I agree, if we want an order, we'll have to approach the court.
Advocate, with the greatest of respect, I don't think that I do have any powers or jurisdiction to determine what happens in the foyer. Our powers and jurisdiction starts in this building when we sit for the hearing and ends as soon as we leave this chamber. What happens thereafter, the greatest of respect, I think there might be other forums which might help you and not this forum.
Mr. Chair, can I just take an instruction on the foyer issue? Mr. Chair, we will accept your prima facie view that you don't have jurisdiction in the foyer and that you're limited to the auditorium.
Any other person who wants to make input to this debate before we make the order? Okay, Troy. Mr. Troy.
Me.
Just on the gentleman in the back, can you just switch off your mic? We'll come back to you. Thank you.
Thanks, Mr. Chairperson. I have listened to my colleague making argument in this matter, and I think the concession they made in as far as the jurisdiction of this commission, in as far as the FOIA is concerned, and accepting the fact that it's a prima facie view which the commission might have is correct, and I have no further submission as far as that issue is concerned, Chairperson. Thanks.
Good morning, Chair. My name is Barry Bateman, Eyewitness News. Chair, on the issue of the media, if it would perhaps be granted by this commission that as a media person that we could speak to our editors who might be interested in seeking counsel on this matter and taking some advice to make representations to you, because clearly this application being brought is a curtail on media freedom. So if we could just be granted that couple of minutes to check with our editors.
When you say couple of minutes, are you referring to 1, 2, 3 minutes or 4 minutes?
Chair, it would be 5 minutes, a quick call to the editor who would make a decision whether they'd like to take it further, and I can come back and report to you. I'm sure my colleagues will probably be doing the same, particularly from the print media. I think they would be interested in seeking some guidance from our employers, really.
5 minutes. Thank you.
5 minutes.
Mr. Commissioner, also as the SABC, due to the public interest in this investigation of fraud and bribery in the 1999 arms procurement packages, there's been a lot of interest. The public relies on us for information. There's been a lot of questions that have been raised about the credibility of the commission itself. So if the media is being denied access into this particular key witness, this will be a nail in the coffin. We will also would like to consult with SABC lawyers for advice, because as we speak, we are streaming this commission live, and a whole lot of people are expecting to see the witness on television today.
Mr. Commissioner, Mr. Chairman, if I could just make it clear, we don't have any difficulty with the streaming of the voice recording live. We have no difficulty with that. It's only the photographic section that we request you to make an order on. So we just want to make it clear insofar as the person on behalf of the SABC maybe have misunderstood. We don't have any difficulty of allowing them access and or publication of the evidential material being led, and they can do it live. We have no difficulty.
Just follow up, Commissioner. SABC TV News, we are a television medium. We rely on visuals to tell our stories, both for our digital platform as well as television. We do have radio stations that rely on audio, but radio stations are also very much attached to the social media. Whatever audio that they broadcast, they also have to put content online, which has to be backed up by pictures as well as footage where possible. So we would like to consult with our legal team at the SABC. As I said earlier, that the South African public relies on us to relay the information to them live.
Mr. Choke, probably when you talk to your legal representative, I want you to assist me in this regard. If the witness says to me that when he testifies, if you focus on him, that makes him uncomfortable, and we might not get the best evidence out of that witness for as long as you focus on him when he testifies. Will that not be a justification not to allow your TV cameras to focus on him when he testifies? I think try and raise that also with your legal representatives. My prima facie view is that once we have a request which says that don't give us an order which asks the media not to focus on me when I testify, because otherwise that might disturb even my thinking my thinking trend. We might just be inclined to grant such an application. We have done it in the past, particularly when he testifies. Maybe raise that with the lawyers, and we'll adjourn for 10 minutes and come back after 10 minutes, and we'll give our ruling at that time after we've heard what your lawyer's attitude is. Okay. Any other person wants to say anything? Thank you.
If I can maybe assist, this is in line with the so-called Oscar Pistorius ruling as well, Mr. Chairman, where the witnesses felt intimidated by the focusing of video cameras and or photographic material on them whilst testifying, and exactly the same ruling was there, and it was never challenged by the SABC, who also televised live the whole proceedings, as you
I'll tell you, the SABC didn't challenge it because I suspect they also wanted the witness to be comfortable, not to be intimidated, so that the witness can testify and assist the court. And I'm sure in this instance, this is the attitude that they will take. But then let's adjourn for 10 minutes, and we'll come back after 10 minutes. Thank you.
Yeah, or more.
your view, what is a reasonable time?
Well, Chair, not being a legal expert and not understanding the exact process that needs to be going through here, but I understand our council would have to seek papers and the application being submitted to this commission. Perhaps later this afternoon or tomorrow morning.
Commissioners Musi and Seriti, I would like to confer with my colleague from Eyewitness News. We've also been in consultation with our legal team and the news editors, and they are also requesting more time in order for our legal team to be able to make certain submissions here at the commission to consult Advocate Mdumbe, because they're saying the publication or the showing of the footage of Mr. Panatongwane is in the public interest, considering the allegations that have been leveled against him for all those years. So they are also requesting reasonable time in order to prepare the papers.
Before I continue, Mr. Chair, what is a reasonable time?
I think also maybe before close of business today, they're actually trying to, they will be consulting Advocate Mdumbe in a short while.
I'm not quite sure what Advocate Mdumbe has to do with your application. That is why I'm trying to find out, what do you deem to be a reasonable time? The last gentleman, from what I could understand, he seems to be suggesting that if they're given this afternoon, then they will be ready tomorrow morning. Will that be the position of your team?
That will also be our position, Commissioner.
Thank you. And the gentleman next to him?
Good morning, Commissioner. I'm Madam Pinson from Yield and Media 24. I've also spoken to our editor, and they also say that they're also planning to oppose the application. They're also busy consulting with our legal advisors at the moment, and they also ask for just for more time, maybe probably, as my colleague said, late in the afternoon or early tomorrow morning. Thank you, sir.
Thank you.
Chairperson, my name is Sarah Evans. I'm from the Mail and Guardian. If I may make a suggestion, I don't think that we're in a position to speak on behalf of our lawyers for how much time they may need to consult. And our lawyers have basically said the same thing as the other media houses. So would it possibly make sense to adjourn for, maybe until after lunch, so that we can get a sense from our lawyers as to how much time they would need to draft papers? I also understand that there's no written application, and we would request that that could be given to us as soon as possible.
Which written application are you referring to? Because I'm not aware of any.
Well, the application that Advocate Cilliers has made.
But then I think it was an oral application. I'm not quite sure which written application you're referring to.
Well, our lawyers would like to understand exactly what it is that Mr. Cilliers is asking for. So if there is a written application, we would like to see it. If not, again, I would just have to convey the message to my lawyers.
I think most of the journalists seem to suggest that if they are given time until tomorrow morning, that will be sufficient. And I think this is what I'm inclined to agree to, because we really want to get on with the evidence of Advocate Longwan. I think if it's always a question of giving people a chance up till tomorrow morning, we might be inclined to make such an order. We are not inclined to give a general adjournment, depending on how long your legal representative thinks that they will take in order to prepare their papers in order to oppose the application.
Chairperson, I do understand. My point is simply that we can't speak on behalf of our legal representatives who probably should, be speaking on our behalf here. So I just think, if we could just have an opportunity to consult with them again, and so that we've only just had a couple of minutes to chat to them. I can't see that it would be a problem to adjourn until tomorrow. I just feel, it's a bit unfair to put us on the spot and expect us to be able to tell you how long the adjournment will take. We're not lawyers, with the greatest respect.
I don't quite understand what you're saying, but in any event, I think I understand what the other journalists are saying, and I think I'm inclined to go along with them, depending on what Advocate Celia has got to say. Advocate Celia?
Mr. Chair, my present instructions is that we don't want to get involved in legal games, and I'm to some extent astonished by the reaction that we have. Can we have a 5-minute adjournment to get an instruction? Our client really, what we foresee now is that we're going to play legal games for the next month or 2, 3, and to the detriment and the prejudice of the Commission. And our main instruction is that our client wish to assist the Commission insofar as he can. Can we get a 5-minute adjournment? Let's make it a 10-minute adjournment to ensure what the position is and maybe consider withdrawing the application.
Chair, I don't have any objection if we adjourn and maybe come back after 10 minutes.
Advocate Celia, I think in that case we are going to adjourn. You can take as much time as you want, particularly if you're considering withdrawing the application. Even if you say we must come back after lunch, we'll be prepared to meet you halfway on that one. So we are going to adjourn, and as soon as you're ready, then you'll send a word to us, and then we can reconvene. From what you're saying, you'll need about 10, 15 minutes.
Yes, Chair. No, we know that the Commission is probably only available till tomorrow, and what I hear from these people is we're moving into court applications and appeals, and I wonder whether we will finalize that before the end of the Commission's mandate, and we don't want that, and therefore our client's view is that he will discuss it with us and he will reconsider.
Talking for myself, I think if your client can consider withdrawing this application, that will go a long way to assist us to get his evidence and get over with it.
That's his approach now as well.
Just a minute. I see now it's 12 o'clock. Can we come back at 12:15?
That will be fine.
Thank you. We'll adjourn again.
All rise.
Can we have a bit of order, please? Thank you. Can we have a bit of order? We want to start with our proceedings. Advocate Sile.
May it please you, Mr. Chairman, I indeed have instructions that in order to assist the Commission and to avoid this media hype that has been created and maybe cause the situation where you will not have the evidence and or the contribution of our client, Mr. Shlongwane, he gave me instructions that he withdraws the application and is ready to proceed with evidence.
Thank you. Advocate Pang.
Thank you, Chairperson. Chairperson Advocate Hlongwane is ready to take an affirmation. Thank you, Chair. Before
Yes, Advocate Pang.
Thank you, Chair. Before Advocate Hlongwane proceeds with his evidence, I'll just give a synopsis of the evidence he's going to give. He will testify basically on term 1.5 of the terms of reference, which states that whether any person within and or outside the government of South Africa improperly influenced the award or conclusion of any of the contracts awarded and concluded in the SDPP procurement process. If so, whether legal proceedings should be straight against such person and the nature of such proceedings, whether in particular there is any basis to pursue such persons for the recovery of any losses that the state might have suffered as a result of their conduct. In this respect, he will also proceed to deal with the whole question that has been on the public domain, that is the quantum in respect of the amounts that he is alleged to have received and the justification of that quantum. And he will, in line with that, also deal with the issue of class and race. And he'll also deal briefly on the impact of the rule of law when he makes reference to the various investigations which were lodged against him. And lastly, he would want to deal also with the issue of failure to accept political outcomes. I would then proceed, Chair, to lead Advocate Hlongwane. Advocate Hlongwane, you have your statement before you in the
Just hold on, Advocate Pang.
Thank you, Chairperson and Commissioner Musi. You will see that there is a bundle of documents and also a separate affidavit marked from page 141. It is separated from the bundle for a particular purpose because Advocate Hlongwane would like to do a comparison between the affidavit which is in the bundle and this one. So we've just put it separately so that when he does that, it is practical to do so. Advocate Longwane, are you ready to proceed? Yes. Yeah, you have made a statement for the purposes of giving evidence before the commission. And if you look at page 1.12a, you have also signed the statement. Am I correct?
That's correct, Advocate.
Chairperson Commissioner Musi, your statement is not signed, but we will give a copy of the signed copy later. Thank you. Advocate, can we then proceed to paragraph 1 of the statement? Can you just quickly take us through paragraph 1 of your statement?
Do you mean I should read paragraph 1? I, Fana Hlongwane, do hereby provide the following statement regarding my and my related companies' alleged involvement with the strategic defense procurement package of the government of the Republic of South Africa, herein referred to as the SDPP.
Advocate, when you refer to your related companies, which companies in particular, can you mention them?
Ngwane Aerospace.
And can you then proceed in with paragraph 2?
Thank you. The object of this statement is to provide the Commission with the relevant facts pertaining to my alleged involvement in the SDPP in order to assist the Commission to properly evaluate the facts and prepare its report in terms of its mandate.
And in paragraph 3, you simply dealing with the terms of reference that you want to assist the Commission to comply with its mandate and having regard to the terms of reference. And in particular, if we go to paragraph 4, you also mention that you cannot assist the Commission with the terms of reference 1.1 to 1.4 and 1.6. Am I correct?
Yes, that's correct, Commissioner.
And paragraph 5, I've already read paragraph 5 into the record. It is a relevant term of reference that you want to assist the Commission with, namely whether you would have improperly influenced the award or conclusion of any of the contracts awarded and concluded in the SDPP. Am I correct?
That is so.
Paragraph 6 of your statement, you mentioned that it is common cause that no evidence has been presented to the Commission indicating that you or your companies influenced the award of the SDPP contracts. Can you maybe expand on that?
During the entire period of the Commission and all its hearings, I strained my ears and everything in my body to hear anybody from anywhere that would present evidence about my alleged involvement in the process or award thereof. Unfortunately, to this day, I haven't had any.
Thank you. Paragraph 7, you mentioned in paragraph 7 that you were never employed by the government of the Republic of South Africa. What do you mean by that?
Commissioner, this means that at the advent of democracy in 1994, the government of the day needed all sorts.
I'm sorry, if you don't mind, can you just pick up your voice a little bit? We struggle to hear you.
My apologies, Commissioner. Is this better? Thank you, sir. At the advent of democracy in 1994, the new ANC government obviously needed all sorts of capacity, and an institution of advisors was established Treasury Instruction S3, I think, if I remember well, whose purpose was to create consultancy capacity for ministers of the various portfolios for them to execute their duties. And such contracts was clearly stipulated to the people who had such appointments that they were not employees of government in any manner, shape, or form. They may not interfere with the departments, with the respective departments, and they may not bind or do anything around the employer. In terms of reference, part of the clauses in that certainly you didn't have pension, medical aid when the responsible minister, if he were to die or leave office or be reshuffled, your job would be over and those kinds of things. And in the contract, it specifically states, Commissioner, that we are appointed as independent contractors. And it is established practice that people could do any other work beyond the work that they would do in terms of their consultancy agreements with the relevant political heads.
Thank you. In short, you say you're not a public servant. Do I understand you to say that?
I never was, and I'm not now.
Maybe whilst you are there, it may be then appropriate to refer to the agreements that you are referring to with the relevant clauses. If you, page 1 of the bundle, Commissioners. It's pages. Can you just assist me to the page? Page 1. Yeah, on page 1, you will find it's an agreement that was concluded between yourself and the government of the Republic of South Africa, wherein it was represented by Joe Modise in his capacity as the Minister of Defense then, and yourself. And this contract on page 4, it was concluded on the 14th of December 1994. Am I correct?
Yes, that is correct, Commissioner.
I'm getting a little bit lost. Which contract are you referring to?
Chair, you'll see that the statement goes until 1.15, and immediately thereafter, then you have 1, 2, 3, 4, 5. So it is the agreement marked FH1. So just mentioning that on page 4 of the contract, it indicates that it was concluded on the 14th of December 1994. Page 4 of the agreement, clause 23. It says the advisor acts as an independent contractor and not as an agent or employee of the employer, and has no authority from the employer to bind the employer. Are you referring to this particular clause when you want to emphasize that you are not a public servant?
Yes, I am, Chair, referring to this particular clause and the briefings that all as advisors were given at the material time.
Okay, we will revert to the contracts later. Now, let's proceed to paragraph 7.2. If you can just take us through that.
Sorry, Chair. I became involved as a consultant to BAE in order to assist British Aerospace at the time, BAE Systems now, with the implementation of their National Industrial Participation Program. My company's rationale for its involvement as consultant to BAE is fully explained in the BAE submission to the Commission. My company's involvement was underpinned and supported by contract and documentation, which is already before the commission.
The BAE submission you are referring to is also attached to the bundle on page 23, 246, as annexure FH5. If you can just go to page 23. Can you identify the document? It's written Statement to the Commission of Inquiry into Allegations of Fraud, Corruption, Impropriety or Irregularity in the Strategic Defense Procurement Package by BA Systems PLC. Is it the submission you're referring to?
Affirmative, Chair. That is the submission I'm referring to.
If you proceed then to page 36 of the same submission, it then deals with the topic NIP. Can you see that?
Yes, I can, Chair. Thank you.
Now, if I can read it into the record, it says the NIP obligations amounted to US 7.2 billion and were required to be discharged over an 11-year period ending in 2011. The NIP objectives set down by the South African government were, and it mentions those objectives. Can you see that?
Yes, I can, Chair.
Now, at the bottom, it also indicates that the NIP program achieved these objectives via a package of major industrial activities spanning many industrial sectors. It sought to focus on the technological and industrial areas that had been identified by the Department of Trade and Industry as priority areas, and which, through the nature of the projects and the companies involved, would help the South African manufacturing market develop across borders. Now, were you also involved in this whole process of the projects in respect of the NIP?
To the extent that my contract stipulated, yes, that is so.
And finally, on the same paragraph on page 37, the last one, it says, in October 2011, the Industrial Participation Control Committee informed BAEs that it had successfully met its entire NIP obligation of US 7.2 billion. This was confirmed by the South African Department of Trade and Industry in March 2002. Do you agree with that statement?
From the South African government, in particular the Department of Trade and Industry, confirming the said statements.
Advocate Parker, probably for the purpose of the record, is 2012, March 2012, and not 2002.
Thanks, Chair. In March 2002, I thank you for that.
Thank you.
We'll revert back to the submission later. Maybe if you can go back then to your statement. If you can then go back to paragraph 8 on page 1.4 of your statement. If you can read paragraph 8 into the record.
I can further categorically state that I do not pay any gratification to anybody who was involved in the procurement process in order to influence such person relating to the award or conclusion of any of the contracts awarded and concluded in the Strategic Defense Procurement Program. I did not participate in the decision-making process relating to the procurement process and can therefore, unfortunately, not assist the Commission in this regard. I can further state that I have no knowledge of any other person paying such gratification to influence the award of contracts. I can also state that I have no knowledge of the fact that any person who had been involved in the acquisition process had received any gratification relating to the award and or conclusion of the contracts.
Thank you. Now, in paragraph 9, you are basically repeating the fact that you are appointed as an advisor to the then Minister of Defense and that you're never a government employee, but you proceed then to discuss further that your obligations towards the minister were set out in the agreement you concluded on 14 December 1994. If we can proceed to the agreement on page 1, FH1. Page 1, FH1.
Thank you.
Paragraph 1 of the agreement, Annexure FH1, states that the employer will appoint the advisor to perform a specific advisory service in respect of the following: legislative, constitutional matters, legal matters with relation to the political as a national defense media, and any other affecting the fulfillment of the employee's mandate, preparation of documents as required in relations of A, B, and C above, any other matter that the employer may deem necessary for the fulfillment of his duties. Were these your obligations as an advisor?
To the then Minister of Defense, Joe Moody, say yes, Chair, that is so.
Now, on paragraph 10, you are referring to clause 18.2 of the agreement, which states that should Minister Joe Modise at any stage during the course of this agreement relinquish his office as Minister of Defense for any reason, this agreement shall automatically lapse on that date that he relinquishes such office. What is the significance of this clause?
In my view, Chair, if anybody thought one was a public servant, so surely there was no employment security, and it was clearly stated to us that we are consultants to provide a particular service at a particular period in the development of the democratic state. And therefore, we should be under no illusion that whoever appointed us to advise them and them only. And should they relinquish their posts, so do we with them go, whether by death or for any other reason.
So your term of office was linked to the term of the minister. Am I correct?
Yes, Chair. If the minister, for instance, were to be reshuffled after 6 months, so would I be gone with my contract? Thank you.
And there were several agreements that were concluded, which are also in the bundle. It appears as if it was annual agreements, or what was the duration of these agreements?
Because of the nature of the job, there was no guarantee whether you're there or not. It was a consultancy in essence. So it was not permanent. There were times where the agreement would be 6 months, there were times where it would be a year, and so on. So they would be renewable. You enter into fresh negotiations, and depending on whether the particular client is happy with you at the time. If not, the agreement is terminated.
Thank you, Advocate Longwane. I think we've already dealt with clause 2023 in respect of the fact that you are an independent contractor. Paragraph 12. You indicate in paragraph 12 that the termination of your agreement with the Minister of Defense was agreed upon during 1998, with effective date of termination being the 31st of January 1999. Is that correct?
That is correct, Chair.
Now, you also indicate that you were appointed as a director of Denel from the 1st of June 1998. Is that correct?
That is correct.
So would I be correct then that after 31st January 1999, you had no role to play as an advisor of the Minister of Defense?
Indeed, but technically speaking, it was already mid-1998. We just agreed with the administration in the Department of Defense at the time that the effective date of termination shall be agreed upon as 31st January.
Now, can you just read paragraph 13 into the record and, if necessary, expand on it?
It must be emphasized that it was never within the ambit of my duties to advise the Minister of Defense on matters relating to the Strategic Defense Procurement Program, and more specifically, as to the preference of any of the options submitted by the bidders. It's written here in the arms deal, but in the SDPP.
So during your advisory role as the advisor of the Minister of Defense, you never participated in any of the committee's evaluation, IONT, and so on in respect of the SDPPs?
Contrary to popular folklore, Chair, I was never appointed or requested by the Minister of Defense at the time to participate in the SDPP processes in any manner, shape, or form.
Let's proceed then to paragraph 14, where you are now dealing with the evaluation of the evidence before the Commission. Now, can you just take us through that paragraph 14?
When evaluating the evidence already had by the Commission relating to paragraph 1.5 of the terms of reference, it appears that the evidence can be divided into three categories. One, evidence by the decision makers who finally evaluated all recommendations and took the final decision relating to inter alia, the choice of aircraft, former President Mbeki and members of cabinet. Two, evidence of technical witnesses who participated in the evaluation of the various tenders. Mostly witnesses who were members of the Department of Defense. Three, evidence of critics in codes of the arms deal in codes who alleged untoward conduct in the Strategic Defense Procurement Program.
No, in paragraph 15, then you refer to the evidence of former President Mr. Thabo Mbeki and various other cabinet ministers who testified. That is former Minister Manuel, Ewin, Casserols, and Lekota. Now, can you proceed then to deal with their evidence on paragraph 16?
The evidence, Chair, was clear and unequivocal. They rejected any suggestion of improper influence relating to the award or conclusion of any of the strategic defense procurement contracts. Apart from the fact that their evidence was clear on this issue, their evidence was never disputed. There was not a suggestion of any influence exerted by me or my companies, whether direct or indirect, in the evaluation by either the Presidential Subcommittee or Cabinet. There was not even a suggestion, that I was at any stage involved in this process.
Thank you. Maybe in corroboration of that fact, can we then look at the JIT report on page 83 of the bundle, paragraph 4.6.7, that you wish to refer to? Paragraph 4.6.7.
I'm sorry, Advocate. I suppose when he refers to the Presidential Subcommittee, he means the Ministerial Subcommittee.
Yes, Chairperson. Thanks.
Thank you.
Do you have that page, Advocate? Yeah, can you just read paragraph 4.6.7 into the record?
During the public phase of the investigation, it was explained by witnesses that the Ministers' Committee decided on and prepared final recommendations in respect of the procurement to Cabinet. It was contended by government that the nature of the structure of the acquisition process was such that any corruption in the awarding of the tenders would have had to infiltrate effectively up to ministerial level, which was theoretically impossible. The committee dealt with the selection of the preferred bidders on the basis of the evaluation that was done in the other forums discussed above. it was the contention of the committee that industrial participation can never be used to justify a decision to purchase any equipment. Any procurement must be justified in its own right.
Do you agree with that statement?
In my capacity as a citizen who is aware of what's going on in this country, I concur with the statement.
Thank you. Then let's proceed to paragraph 17 on page 1.9 of your statement. And can you proceed then to read the paragraph and sub-paragraphs into the record?
The expert witnesses dealing with the technical evaluation of the tenders relating to the relevant aircraft was also clear on the relevant issues. There was definitely never any attempt to improperly influence them in their evaluation and or preparation of their conclusions. 2, there was no suggestion of any kind that I was ever involved in these processes. To 18. The third category of witnesses and or potential witnesses were the so-called critics of the Strategic Defense Procurement Program. In their initial submissions, reference was made to me and some accusations leveled against me relating to my involvement with BAE Systems and my position as advisor to the late Minister of Defense, Mr. Joe Modise. When evaluating these submissions, evidence and subsequent conduct of the critics, the following picture emerges. During the evidence of all of these critics, all of these critics admitted unequivocally that they had no personal knowledge and or any evidence to substantiate the allegations and or accusations against me. Some of the critics refused to appear at the commission and testify and to be subjected to cross-examination. Their allegations and accusations in their submissions, of course, flies in the face of all the evidence under oath by all the witnesses with actual knowledge of the acquisition process. There were a number of investigations by a number of governmental agencies in South Africa and abroad, and not one of the investigations produced any evidence of misconduct by me relating to the Strategic Defense Procurement Program. This include inter alia the following: the Joint Investigation Team, JIT Inquiry, the Director of Special Operations, Scorpions, the Serious Fraud Office of the United Kingdom, SFO, the South African Police Service investigation by the Hawks.
Maybe then let's deal with the Joint Investigation Team. We have briefly referred to the references in the report, but let's proceed then to page 95 of the bundle, paragraph 4.12 of the JIT report. Can you then read paragraph 4.12.2 into the record?
The decision to recommend the Hawk Gripen combination to Cabinet as the preferred selection for the light intermediate fighter trainer and the advanced light fighter aircraft was taken by the Ministers' Committee for strategical reasons, including the total benefit to the country in terms of counter-trade investment and the operational capabilities of the South African National Defence Force.
What's your comment to that statement, Advocate?
Given that I was not involved in this process, my comment would be of academic value.
And if you can read on page 96, against the background that there were allegations that the the prices of the Lift and Alpha were inflated so that it could enable BAE to pay commissions. Now, can you read paragraph 4.12.6 into the record on page 96?
No evidence could be found in support of the allegation that South Africa is paying more than the normal basic unit price for the Hawk and Gripen aircraft.
Do you have any further comment on that statement?
As my non-involvement was canvassed before the Security Commission, and my non-involvement is common cause, I am unable to comment on the statement. Thank you, Chair.
Thank you. So it is common cause, advocate, that you concluded certain consultancy agreements with BAE, as you have already indicated, during 2003, where you engaged as an advisor. And in particular, in their submission, BAE makes references to the whole question of advisors, how they went about to appoint them. And it may be important just to read through page 37 of the bundle, paragraph 6. And I will then read the paragraphs and ask for your comment. Page 37, Commissioners. BAE's engaged advisors in relation to BAE's and SAB. BAE's paid approximately 115 million pounds to advisors in connection with the sale of civil and military aircraft, including Hawk and Gripen, in South Africa, and in fulfilling offset obligations. Were you also paid for your services, Advocate Hlongwane, as an advisor?
In accordance with my contract, Chair, yes, I was.
Now, if I can proceed then to read the next paragraph, it says that some campaigners have suggested that the payment of these commissions is evidence in itself that there was corruption in the procurement process, and they refer to the Institute for Accountability, I think, which is led by Advocate Hoffman, and he has, when he was leading Mr. Crawford Brown, also made reference to when he was, yes, when we was cross-examining at President Mbeki, make reference to the fact that these commissions were bribes. What's your comment on that?
The opinions.
May proceed then to read just the penalty paragraph. It says there that the Institute for Accountability's letter to the then evidence leader of the commission, dated 14 November 2004, submitted that the word commissions meant bribes. These assertions do not accurately characterize the statement made by the Secretary of the State. They also reflect a misunderstanding of the nature of the procurement process. What's your comment on that?
Take me back, sorry, Chair. What paragraph is that again?
Just before the last paragraph on page 37, where I read the Institute for Accountability. Yes.
And the question is?
What's your comment on that statement?
As I understand, Mr. Hoffman was here and he cross-examined former President Mbeki. And the points he sought to canvass, he dismally failed at canvassing those points. And as all the evidence before the commission suggests, these points of views do not have credibility unless supported by evidence. For a better part of 15 years, the country has been waiting for this wonderful magical evidence. that the democratic government of the day was involved.
I'm sorry, sir. Can you pick up your voice again, I think?
My apologies once again, Chair. It's my first experience at commission, so I'll get used to it. My apologies once again.
Your response.
I'm saying for the better part of 1.5 decades, all manner of accusations were made against the democratic government. Misconduct, corruption, fraud. And to the extent that no evidence has been led to prove such, it makes one wonder what the Commission will do in its report, and the country for that matter, about the obstinate refusal to accept democratic outcomes by certain sections of our society. It makes me wonder, how is it then that a lunatic fringe and rogue elements within the law enforcement agencies can actually set the agenda for the nation, that in the middle of Christmas holidays we are here? For what? So maybe the commissioner will assist and indicate, given that previous governments have made such decisions before, they were never questioned. In my understanding of democracy, you go to elections as political parties, you canvass the people, you win, you form a government. As a government, you have the duty to govern, you make choices within the context of the law, as has been stated by former President Mbeki and many other ministers here. And that's exactly what they did. Any other right-thinking South African knows that. One should not be tempted to introduce the narrative of race and color in this, but it makes people wonder what actually is the story. As a matter of fact, the chair, I'm sure, would know that the democratic government found this procurement process in progress in the Ministry of Defense. They were continuing that which was started. It may be that the issue is that the selected bidders may not have been to the favor of the people that had economic interest in the defense industry, who then decided to set an agenda for the media to attack the government of the day with this narrative of corruption. And that does not mean, Chair, that we condone corruption. It must be fought vigorously. And as I suspect, this commission is about the fight against corruption. Thank you, Chair.
Thank you very much for your response, Advocate. If we proceed then on page 37 of the submission, you will see the BAE makes a point. They say there that the use of advisors by international companies exporting to countries where they have no material in-country capability or staff was and is commonplace across many industries. This approach offers a lower cost base for long lead time programs compared to basing staff in country, ultimately leading to a lower cost of sales to the customer. It is widely accepted that offset obligations require contractors to employ advisors to perform roles which include providing local knowledge of market-specific procurement processes and practices. Are you agreeable to that statement?
That is indeed common practice, Chair. It would be difficult for me to disagree with this particular statement, but maybe I'll ask another question to the Commission. Maybe the issue becomes if it is a Hlongwane providing the services, because even in terms of this very discussion, there are many other people who provided advice as consultants to PAE. Their names were never as aggressively canvassed in the media. People talk about huge sums of money as if quantum is the issue. But there's a loud silence about those names in the media. I am not suggesting anything peculiar, but perhaps the Commission will apply its mind to this particular matter. Why is it an issue when it's a Hlongwane? Because we want to build a united country. I'm not going to say because Hlongwane is black, then there's an issue. Or blacks don't have the right to earn money, or blacks cannot have, etc., etc., because that might be misdirecting the discussion. But it is an issue for me. There are many other people with greater sums. This thing has been happening all over, not just in defense, in many other areas. So maybe you'll assist me with the chair of the commission to tell me what is it that I've particularly done that I must come and justify participation in what is standard international practice across all industries.
Thank you, Advocate Hlongwane. If I may proceed then to the next paragraph, it says there that in the 1990s, BAE's sales strategy worldwide was to incur no cost in country itself, but rather to engage local advisors upon whom the costs fell. Further, the advisors assumed all the financial risk of the procurement process, saving BAE's a fixed overhead, which in the case of South Africa, BAE's estimates, based on the cost of other overseas offices, to have been in the order of approximately £4.2 million annually. Are you agreeable with that statement? And can you comment if necessary?
Chair, I cannot comment about when BAE adopted the strategy, nor can I comment on the quantum, but the principle, yes, I'm in agreement with the principle.
Then if you look at the last paragraph of the page 38 of the statement, it says that the conduct of advisors relating to BAEs and sub-products in the course of the SDPPs has been subject to a number of detailed investigations over many years. None of these investigations has demonstrated unlawful conduct on their part. Are you agreeable with that statement?
Yes, Chair. I'm agreeable to the statement, except that it uses a plural. It says the conduct of advisors. So far, I see the conduct of Hlongwane being subjected to investigation. Of course, the Commission will help me in this as well. Thank you.
Then if you turn the page, the next page, I think it's page 38, just concluding this submission. The second paragraph. Well, the whole page speaks about investigations which were lost against BAE. But in respect of this paragraph, it says in February 2010, BAEs agreed with the SFO and the Department of Justice the basis upon which the investigations should be concluded. In the UK, BAEs agreed to plead guilty to one charge of failing to ensure that the books and records of one of its subsidiaries were reasonably accurate in relation to a transaction in Tanzania and to make a payment for the benefit of the people of Tanzania. In the US, BAEs agreed to plead guilty to making false statements to the US government and certain export control violations. None of the charges against BAEs related to its activities in South Africa. BAEs did not plead guilty to any offenses of bribery or corruption. Do you agree to that statement?
It's a BAE matter, Chair.
And the last paragraph also refers to the fact that there was a joint investigation team which was appointed, and also it found no evidence of improper or unlawful conduct. Did you participate in the JIT hearings, Advocate Hlongwane?
No, Chair. This is the first time that I'm appearing before any commission or structure. The conclusion of this contract. It's the first time.
But we are also a subject of investigation by the Serious SFO in the UK, and also the DSO, the Scorpions, and the Hawks. And it is common cause that there were also search warrants which were seized from your properties. Am I correct about it?
Chair, I later discovered that I was a subject of investigation by the SFO. The SFO never approached me. I was never informed of any investigation. I always traveled in and out of the UK to service my clients at all material times. I was never stopped at any airport or asked any question. Equally, there were reports that I read that the DSO itself is investigating me, but I've never had any contact with anybody from the DSO to tell me such, except an ex parte application around 2008 to Justice van der Merwe, where in my most humble and respectful submission, Chair, manufactured and fabricated evidence was presented to the judge for him to grant the search warrants. And I've asked my legal team to kindly pursue this matter vigorously with this respected commission, as it's to the rule of law, as it relates to how we conduct ourselves as responsible citizens and the law enforcement organs of the country, because we are going to end up teaching our children funny and strange law, creating dubious precedents because of the unlawful conduct of rogue elements within the justice system in the name of the administration of justice. I feel strongly about that, commissioners, and I would like the commission to assist in that regard. I've asked my senior counsel to address this matter with the evidence leaders, wherein the celebrated affidavit of Murphy is used in the many books that are written by the Amstel critics, which is an orgy of mutual quotations and the perpetuation of ignorance. The very basis of that affidavit is a problem. Commissioners, in one case, on the same day, the same person is alleged to have signed an affidavit. It's 34 pages from the same sources, the NPA, the commission. Same person signs an affidavit, 37 pages, with material differences in wording and the insertion of paragraphs to justify a particular outcome, to justify search warrants, and to pursue a particular agenda which I'm sure the Commission is best positioned to address. Thank you.
For enlightening the commissioners, may I then refer you on page 104 of the bundle? It's the affidavit, Chair, of Gary Daniel Murphy, who is indicated as the principal investigator employed by the Serious Fraud Office, the SFO. And should I also refer you to the separate affidavit, which I've also put before you, Advocate, marked page 141? It's a separate document. Now, I would like you to open the last page of page 140 of the document and page 174, the last pages of both documents. That's pages 140 and page 174, Commissioners. Now, maybe you want to illustrate as a matter of example why you say that there are distortions in these affidavits by referring to the last pages of the affidavits and taking the commissioners through that page.
Excuse, pardon. By way of example, if you look, when you look, pay attention to this particular page. The paging on one is 37, on the other is 35. Number two, if you go to the paragraph above, you will see the font is different. The words are together in the above paragraph, and in the 174 one, the words, there's a huge distance between the sentences. Thirdly, if you look at the first sentence, it states, I certify that the deponent has acknowledged that she is cancelled, knows and understands. But in the other one, there is no such cancellation of she, of the word she. Further, Commissioners, the date of signature on this last page, on the one, by the same person, it's written 9 October 2008, and in the other, by the same person, is 9 October. The 2008 is not included there. I am no handwriting expert, but I'm sure the Commission, in its wisdom, will pursue this particular matter. If you look at the two signatures of the said person, the signatures are a poor forgery. If you pay further attention to the name, full name in print, Benjamin John Halsley, if you look at the J's, just looking at the J's here have heads. In this other one, such is not the case. You look at the way the E's are written, and they are certainly different. There are many such contradictions in this document, Commissioners. Many. I was saying to my legal team that there is a Hlongwane clause in this in this affidavit, because there was something that was inserted to persuade Justice van der Merwe to make a particular ruling. Now, not knowing which of these particular affidavits are indeed true and original ones, we find that the affidavit by the DSO in the ex parte application to the judge contains these fundamental problems. If one is faced with the might of the state as an individual and there's this kind of unlawful conduct, it makes one wonder, what is the future of the rule of law? Thank you.
Thank you very much, Advocate. And I see you've dealt extensively with the comparisons between the two affidavits further in your page 1.13 to 1.15, am I correct, of the Murphy affidavit? You can just say, speaking to the record, do you agree with it?
Sorry, Chair, what I missed that?
I say that in your affidavit on page 1.13 to page 115, you have dealt with the comparison between the two affidavits.
Let me be sure. Yes, that is so. Thank you. I didn't understand the question. Sorry, Chair. Thank you.
Now, I've also make a reference to the submission that was made by Andrew Feinstein and Paul Holden, annexure FH7.
Maybe this might be an appropriate time to take the adjournment. And maybe let's take the adjournment for 30 minutes.
I was only 5 minutes away from finishing, but
Only 5 minutes away from finishing. Then that means that we should take an adjournment because we'll finish after the adjournment.
thank you, Chair.
So let's take an adjournment for 30 minutes. Thank you.
Quickly.